The European Convention on Human Rights states that everyone has the right to liberty and security regardless of mental capacity or disability. In this film, consideration is given to the Supreme Court judgment on deprivation of liberty led by Lady Hale, which clarified that people who lack capacity to consent to the arrangements for their care and treatment have the same rights to liberty as anyone else.
Well, the Supreme Court were responding to Article 5 of the European Convention on Human Rights, which provides very, very strict limits on when the state can deprive people of their liberty on the basis that they're unsound in mind. They're very carefully circumscribed circumstances. I think it's actually also right to say that when you look at what Lady Hale is saying, and she gives the judgment, the lead judgment for the majority, what Lady Hale is really looking at is not so much, in a funny sort of way, Article 5, which is the right to liberty, but Article 8, which is the right to private life, which the European Court of Human Rights and our courts have interpreted as including the right to autonomy.
Here, a panel of MCA experts look at the implications for practice of the Supreme Court judgment ruling and the huge increase in requests for authorisations under the deprivation of liberty safeguards.
We have all come here together today because it's been about a year now since the Supreme Court gave its landmark ruling really about deprivation of liberty, which has caused a huge amount of interest in our world, the world of the Mental Capacity Act and dolls. How has the Supreme Court judgment about deprivation of liberty changed what a best interests assessor or independent mental capacity advocate looks for in a care home or hospital ward?
I'd be looking at the acid test, which is something that came from the Supreme Court judgment. I would be looking to see if there's a least restrictive way of doing whatever's required to care for the person.
As the principles of the MCA haven't changed, when an IMCA goes to work with a person, they're looking primarily at what that person is saying, what they are articulating, what they're communicating to an advocate. Factors around, well, could that have been done less restrictively, are certainly at the forefront of our mind, but really trying to put that person to the forefront of a decision. And that hasn't changed.
There's been a perception that the law changed completely in March 2014 as a result of the Supreme Court decision in Cheshire West. For reasons we don't need to go into, actually that may not really be correct. It's just simply a clarification of the position as it has always been. But the perception is very much that there's been a change, and that change has been seen as lowering the threshold for what counts as a deprivation of liberty and expanding the scope of the number of people who are considered to be deprived of their liberty. And the change which most people have picked up on is the use by Lady Hale in the Cheshire West decision of the term the acid test to say whether or not someone is deprived of their liberty.
The acid test, the phrase used by Lady Hale to determine whether someone is deprived of their liberty, is comprised of two criteria. Is the person under continuous supervision and control? And is the person free to leave?
Given the real pressures on the dolls processes, how can the dolls managers make sure that they're sending assessors in the right order to respond to the right requests?
This is a big challenge for us, for following the Supreme Court judgment, because up and down the country, supervisory body like us have been inundated with applications for standard authorizations. I think ADAS has quickly put together a group to try and address these challenges. And one of the outcomes of that group is the formulation of a priority list that's been sent out to all supervisory body, and I think that is very helpful.
One of the issues for best interest assessors is, I think, that quite often there is a small period of opportunity to reverse what's happened, and if someone's somewhere they don't want to be, and they've got someone's got a lasting power of attorney, and they've decided that they're going to sell that person's home. By the time we get there, maybe the house has been sold, and possibly the view might be that they would be okay to go somewhere else with a full package of care. and they could have returned home, but home isn't there anymore, so you really feel that the boat has sailed for that person.
What do you think are the practical things that people involved in the DOLS process, so that's the best interests assessors and the IMCAs and the authorisers, can do to protect and enhance the human rights of the people who are being deprived of their liberty?
From my perspective, it's to not lose sight of the principles of the Act in the first place, and to continue using those, and using those in confidence.
You need to find out why someone's behaving in a particular way, or what they're trying to do, because it's quite easy to misunderstand what somebody's doing if they're in a really restricted environment.
Sometimes it's about understanding the person's life story, isn't it? And sometimes BIAs, because of the way often BIAs, because of the way they approach assessments, pick up on these things, and they ask the questions of care homes: why is that door locked? Why would it not be safe to do this? Sometimes they've done something and they've done it for a number of years and not revisited it, not reviewed it, not looked at a genuine, less restrictive way of doing things.
Best practice for BIAs and IMCAs is to focus on the least restrictive option that bears in mind the person's views and opinions, and find the best solution with the right communication for each individual.
Well, the good BIAs I talk to, when they're wondering how they can use DOLS properly, they always see it as something that they can really use as a tool to empower people. They can really think creatively. They can put really creative conditions on a standard authorisation to make sure that what is going on really is not just calibrated to make sure that restrictions are as little as possible, but actually make sure that really good things happen. Make sure that conditions are put in to say that the care home must allow the person to go to the church that they'd always gone to for 50 years. Do things, little things, but things which actually just make a massive difference to that person's day-to-day life. And so, as I say, the good BIA assessors really think that they can do some good with DOLS authorisations.
With my advocacy hat on, it's always got to be about the person and what they want, and doing everything possible to make sure that their views are not only listened to, but their whole person is at the forefront of the decision-making process, and finding innovative ways to support that person be involved. I think that's got to lead these kinds of decision-making processes, because I think the danger is people can feel alienated, and the person drops out, and this becomes process-driven as opposed to person-driven. And I think there are lots of committed professionals, lots of committed advocates and decision-makers who really want to put people at the centre of it, but there are challenges. But I think we mustn't lose sight of what the Act tells us.
It's vitally important that best interest assessors and others involved with the DOLS process, and also deprivation of liberty outside hospitals and care homes, take proper steps to keep themselves abreast of legal developments, because this is a legal landscape that changes, and they absolutely have to be sure they know what's going on at any one time as a matter of law.